late. Anyway, I'm going to go ahead and get started here. This is Steve Dale. I am the trustee of the Golden State Pooled Trust. And for those of you that are watching this, this is the first of a series we're working on, which we call the Essentials of Disability Planning here. And what we're going to do is go through a whole series of programs here once a month here on all sorts of different subjects having to do with a disability law practice. Today we're going to talk about the ABLE Act and some of the changes with a real focus on using ABLE accounts with special needs trusts. For those of you that are watching for credit here, and okay, for those of you that are watching at home, for credit, the Golden State Pooled Trust, which is the nonprofit that works that actually runs the Golden State Pooled Trust, here is a MCLE provider here. There will be 3 codes set within the program. So what you need to do is write down the code. For those of you that are watching live here, what you need to do is email Shelley Sinceri, which is Shelley, SHELLEY, at GSPT.org, and she will send you a form and an evaluation that you can fill out and send in, and we'll give you 1 unit of credit. Okay, here for those of you and for those of you that are not watching live, basically you can follow the same process at this point. Okay, so with this, what we're going to cover here initially is the revised ABLE Act POMS here, which was issued in March of this year. And to do that, you can find it in a number of different ways. If you go to policy.ssa.gov, it will take you to a page that looks something like this. What we're doing here is that we're going through the revised recent changes. So if you hit recent changes, it will take you to this page here. Keep in mind, this is as of April 2018. So this may look a little different. And under resource exclusions is where we will find these POMs. Okay, so most of you know what the POMs are, but they're the Program Operation Manual System here, which is basically they are directives to eligibility workers and field officers on how to handle specific issues and specific problems that might come up. And even though it says, the first thing it says is they're not to be used as precedent, we in the industry use them as precedent all the time. Okay, so another way to do it would be to Google SI space 01130.740, and that will take you straight to the POMs and all sorts of other related sites. Okay, so let's start going through this. Now, if you look at the first part of this, what it's going to say is that it'll go through basically the different changes here that were made to the POMs here. And we're going to go through about 4 of them. The last couple are really more administrative and don't really affect us. Okay, so in Section A, they identified partnerships with different states that can be used to administer ABLE accounts here, and they addressed the treatment of duplicate ABLE accounts. Now let me get this out of the way just as we get started here. I am taping this in April of 2018. Now we had expected that the Cal ABLE program would be opening, if not now, very soon, and their vendor pulled out at the very last minute. Our expectations are that Cal ABLE will be up and running by the end of the year or early next year. Just for myself, you know, I get this question all the time. When will ABLE accounts be available in California? And the fact is they've been available since June of 2016. For myself, I've been using the Ohio program both for my practice and also for my beneficiaries, and we actually are entering into a relationship at this point with the Ohio program. you know, you folks are of course free to use whatever program you like. But when the CalAble program is up and running, you can actually transfer those accounts to CalAble without a penalty. Okay. By the way, for those of you that are watching who have questions, there should be a chat box, and if you type into the chat box here, Amy is tracking these things, and we'll try to answer as many questions as we can here. And I want to apologize, but I have just lost apparently the video here for so I'm going to just take a break real quick, and I really want to apologize to the audience here for this, but pick this. I'd have to, you know, once again, for those of you that are watching, for some reason the PowerPoint is jumping in and out here. Shelley will send you once again the handout for those of you that email her, so you can follow along, and I hope this doesn't happen anymore. Okay, so let's just go through this. Just picking up where I left off. Able accounts are available now, and so as we're going to see, you can use you can use a program in another state, and eventually there may be some very good reasons to move things back to California. So in this here, it starts off by saying the Able account is a type of tax-advantaged savings account that an eligible individual can use to pay for qualified disability expenses. The eligible individual is the owner and the designated beneficiary of the account. And as we're going to see, this is a very important concept. Okay, so an eligible individual may establish an Able account provided that the individual is blind or disabled by a condition that began before the age of 26. I'm going to try something here to see if we can stop this problem. Okay, that began before the 26th birthday. So, and I'm going to do this one last time, and I do truly apologize for this. Okay. Anyway, let's get back to this, and let's hope that doesn't happen. Okay, so what is an Able account? An Able program here can be established by a state. Here, an eligible individual can open an Able account here in any state if the state permits it. One of the things I will send out to the audience is a link to the Able National Resource Association here. And with it, it has a really nice list of Able accounts across the country. So some states have formed partnerships. Some states have formed a consortium. There's two large groups here that have done that. Some have established their own Able programs, but have contracted with private agencies to manage them. And some states have established their own Able programs, but have contracted with other states to manage their programs as well. Some states do not haven't operated their own ABLE accounts and are not expected to here. So once again, it really depends on where you're doing this. In California, once again, they're in the process of rebidding for this, so we'll see more about this. Now, one thing that's key is that you are only allowed one ABLE account and one ABLE account only. So if you were to open up an ABLE account, and I'll give you an example. My wife and I opened up an ABLE account with the Ohio program for our niece, Erica, here. And so if another aunt or uncle did the same thing and opened up a second ABLE account, then once again, that would have to be shut down here within 90 days. Okay, so you're only allowed one ABLE account, and the programs have a way of matching, of tracking when somebody has opened up an account. Now, one thing really important is that upon the death of the ABLE beneficiary, whatever is left in that account after you pay for remaining qualified disability expenses here, is that there is a lien for any Medi-Cal or Medicaid the beneficiary has used from the time the account was established, unless if the state files a claim for reimbursement. At the when we were recording this, there are 4 states that have actually passed a law saying that they do not intend to file here for reimbursements, and those are California, Pennsylvania, Oregon, and Florida. These are only for their residents using their programs, okay? But this is something that, once again, when the California program is up and running, if the lien is an issue, that certainly will give a real benefit for using the Cal ABLE program. In Section B, they changed the references for qualified disability expenses for housing here, and also updated the gift exclusion to $15,000. This is going to be really important. I know for not only for the beneficiaries of the Golden State Pool Trust, but also for many folks that we work with. This is huge. And we'll have some examples towards the end. So contributions have to be in cash and may be made in the form of cash or a check or money order, credit card or whatever here. And it has to be made by a person, but a person, according to the IRS code, does include trust. So that's certainly relevant to our viewers here. And for 2018, that limit is $15,000. Now that is based on the federal gift tax exemption. So there is a cost of living increase. So someday it'll go to $16,000, someday it'll go to $17,000. And this may be subject to change by legislation. So, you know, as I like to say, you might think you have learned everything you can about ABLE, but it's something that's constantly changing. And we at the Golden State Pool Trust will do our best to keep you up to date as well. Okay, so the designated beneficiary is the individual who owns the ABLE account here, and who was the eligible individual when the account was established, or who succeeded the former designated beneficiary in that capacity. In the limited situation here is the law does allow a transfer upon death to a sibling or step sibling if they are disabled and meet the same definition of disability here as far as ABLE accounts are concerned. To be an eligible individual, he or she must be eligible for Social Security, for SSI or SSDI based on a disability or blindness that began before the age of 26. To be entitled here to disability insurance or childhood disability benefits, so you need to be on one of the disability related programs to be eligible. You have the other way to do it is you can do it through a certification process. This comes up a lot when we're dealing with folks with mental health issues. So it's very common that you might have somebody with a mental health issue where they were disabled before the age of 26, but maybe they didn't start getting their benefits until they were 28 or 30 or whatever. You'll see this quite often here. I've had very few cases where we haven't been able to get somebody qualified because of a certification in that situation. But it's really key here that the disability has to have begun before the age of 26. And in order to do that, they have to have a medically determinable impairment that, or meet the criteria of being blind, and the disability blindness needs to have occurred before the age of 26. Okay. Now, one thing about this is that the ABLE programs are under the oversight of the Department of Treasury, and the Department of Treasury has a history of being very disability friendly. So like even in this situation, if you go to apply for most ABLE programs and you say on the application you didn't get your benefits until after 26, it'll ask you for a certification here, and in most cases it doesn't even want a copy of it. It wants you to tell them that you have a copy of the certification. Now, I'm not saying that you should say you have a copy when you don't, but once again, what you need to do is keep it in your files in case you ever got audited. A distribution is any payment from an ABLE account here. And a program to program is not a distribution. So once again, if you open up an ABLE account in another state and move it to California, that's not considered a distribution. A designated beneficiary or a person with signature authority determines when a distribution is made. Okay, and we'll be seeing more about that in a bit. Distributions other than rollovers may be made only to or for the benefit of the designated beneficiary. And that's going to become important later when we start talking about qualified disability expenses. So when it comes back to this concept of a member in the family, there is this limited ability to transfer the account from one sibling to another so long as they are disabled. So under the current law, you can't transfer it to a parent, you can't transfer it to a child. Here, you can't transfer it to a spouse. You can only transfer the account here to a sibling, whether they're adopted, step siblings, or whatever, and that is the limited amount of transfer that can be made. So a new term that we'll all need to learn is that the person who administers the account is the person with signature authority. A person with signature authority can establish and administer an ABLE account for a designated beneficiary who is a minor child or otherwise incapable of managing the account. Signature authority is not equivalent to ownership. Okay, so the person with signature authority must be the designated beneficiary's agent under a power of attorney, or if none, a parent or legal guardian of the designated beneficiary. For SSI purposes, always consider the designated beneficiary to be the owner of the account, regardless of whether someone else has signature authority over this. Once again, as we talk about capacity, this is going to be very important, because as long as the ABLE beneficiary has capacity, it is presumed that they will be the ones with signature authority over the account. A program-to-program transfer means a direct transfer of the entire balance, once again, of the ABLE account of the same designated beneficiary in the first ABLE account, and it's closed upon the transfer of the funds, or part or all of the balance to an ABLE account to an eligible individual who is a family member, keeping in mind we're talking about siblings, of the designated beneficiary. Now, this is something that has changed quite a bit, okay? And I won't actually go through every single thing that's a qualified disability expense, because the POMS added one last thing here, which is that it could pay for all those things listed, including housing, which we're going to specifically focus on, but it also added basic living expenses, okay? Now, what isn't a basic living expense? And a lot of folks that are dealing with ABLE accounts, the only thing that we can seem to agree on is gambling is not a basic living expense. nor as making a gift to someone else here. So really that has broadly, that has made what this could be used for a lot broader. So now for housing expenses here, for the purpose of ABLE accounts, they're similar to household costs and in-kind support and maintenance, with the exception of food. So as we all know, there's 10 ISM items, but for the purpose of housing, there's only 9. And we're going to have a whole section where we're going to cover housing in a bit. But as we're going to see, the benefit for SSI beneficiaries for housing here is a huge benefit for using ABLE accounts. So this is our first MCLE code here. So number 1 will be 4234. For those of you that are watching who do not have the form, please write this down and email Shelly Sinceri here at GSPT, or email Shelly, SHELLEY at gspt.org, and she will send you a form where you can put in this number. So that's code number 1. So in subsection C, we clarify the treatment of contributions to an ABLE account. So what it says is the payment made to an ABLE account constitutes a contribution. Consider the contribution made by the person to whom the funds belong to or are due. Okay, here. Exclude contributions to an ABLE account from the income of the designated beneficiary. And we're going to get into more detail on that in a moment. Excluded contributions include rollovers from members of the family's ABLE account here to an SSI applicant, recipient, or deemer's ABLE account. So the fact that a person uses his or her income to contribute to an ABLE account does not mean that his or her income is not countable as it normally would be. So income received by a designated beneficiary, then deposited into his or her ABLE account, is income to the designated beneficiary. For example, a recipient or deemer can have contributions automatically deducted from their paycheck and deposited into the ABLE account, but it's still going to be subject to the 2-for-1 reduction after the first $65. In this case, include the income used to make the ABLE account contribution in the applicant, recipient, or deemer's gross wages. So that's a good example of where that one of the benefits of using an ABLE account for somebody who is working disabled is the ability to be able to take your wages here and place them in an ABLE account to keep you from constantly going over that $2,000 resource limit, but it's still going to have the same 2-for-1 reduction after the first $65 that all SSI recipients have to go through. A contribution made by the designated beneficiary in his or her account is not income to the designated beneficiary. However, income received by the designated beneficiary and deposited in the ABLE account is income. That is, the income is income in the first instance, but the contribution is not income. So if somebody were to earn $265 in the month, they would still take the $100 reduction, but they could take the remainder of the funds and put it in the ABLE account to save it for a future need. The individual cannot use direct deposit to avoid income counting here. So the fact that you didn't receive it isn't necessarily going to save you from having it counted. So when a payment that belongs or is due to the designated beneficiary is direct deposit in his or her ABLE account, the payment is considered to be received by the ABLE beneficiary. It is then counted as income to the designated beneficiary as it otherwise would be. The designated beneficiary is considered the contributor for ABLE purposes, and the ABLE beneficiary is not considered, contribution is not considered income to the designated beneficiary. So examples of payments that might be direct deposited into an ABLE account but still are not counted as income as they otherwise would be wages, benefit payments here, and mandatory child support or spousal support payments. We'll, once again, as we go through the examples, we'll show you a workaround here where you might be able to do it anyway. Exclude distributions for a qualified disability expense that's not related to housing, for the designated beneficiary's countable resources if he or she retains it beyond the month received. Okay. This exclusion applies while the designated beneficiary maintains, makes contributions to, or receives distributions from the ABLE account, telling us that it needs to be a valid ABLE account. The distribution is unspent and the distribution is identifiable. Okay. The individual intends to use the distribution for a qualified disability expense not related to housing. As we're going to see, that's an important concept. Note, apply the normal SSI resource counting rules and exclusions to assets or other items purchased with the funds from an ABLE account, meaning that you can use it to buy excluded resources, like you could buy a car with an ABLE account, but you can't buy a second car and not have it included. Okay. Third-party contributions are contributions made by persons other than the designated beneficiary. Further, third-party contributions are made with funds that do not otherwise belong to or otherwise due to the designated beneficiary. That is, they are made with the third party's funds. In my case, it would be from, Aunt and Uncle Steve to our niece here. But as we're going to see in a moment here, we may have further problems. Okay. Accordingly, an ABLE account by a person other than the designated beneficiary is treated as a completed gift. Note, a transfer of funds, and this is huge, from a trust of which the designated beneficiary is the beneficiary and which is considered to be a resource, not considered to be a resource to him or her, generally will be considered a third-party contribution. Okay, so what this is telling us is whether it's a self-settled trust or a third-party trust, a pooled trust, or an individual trust, the transfer from a special needs trust to an ABLE account here is a contribution and will not be considered income. And that's going to be really the focus of a lot of what we're going to talk about here. You may seek guidance from your regional trust lead if you have questions regarding trust transfers into an ABLE account, if you can get your hands on the regional center, the regional trust lead, okay? We're in the 9th region, and I'm not clear how you would find this person. A distribution from an ABLE account is not income, but it's a conversion of a resource from one form to another. So do not count distributions from an ABLE account as income of the designated beneficiary, regardless of whether the distributions are for a QDE not related to housing, for a housing expense, or from a non-qualified expense. It also says exclude a distribution for a QDE not related to housing for the designated beneficiary's countable resources if he or she retains it beyond the month received. This exclusion applies while the designated beneficiary maintains, makes contributions to, or receives distributions from the ABLE account. The distribution is unspent and the distribution is identifiable, and the individual intends to use the distribution for a QDE not related to housing. Otherwise, apply normal rules. What the heck does that mean? Well, let's go through an example. Eric takes a distribution of $500 from his ABLE account in June 2016 to pay for a health-related QDE. His health-related expense is not due until September, and Eric deposits the distribution in his checking account in June. The distribution is not income in June. Here, Eric's distribution is both unspent and identifiable until Eric pays his health-related expenses in September. Exclude the $500 from Eric's countable resources in July, August, and September. Okay, well, that's pretty straightforward. Here's another example. Fred takes a distribution of $1,500 from his ABLE account in September 2016 to buy a health-related item, which is a QDE. The item is an excluded resource in October and continuing because it is the individual's personal property required for a medical condition. So when do you count ABLE account balances and distributions? Count the amount by which an ABLE account balance exceeds $100,000 here as a resource of the designated beneficiary. Individuals with ABLE accounts can maintain eligibility for means-tested programs, that's SSI, IHSS, Medi-Cal for those of us that are Californians. But there's really two levels you have to deal with. The first one is as long as the account is $100,000 or less, it does not count for purposes of SSI eligibility. Once it goes over $100,000, it starts to become a resource, and really literally when it hits $102,000, you would lose your eligibility here for SSI, or else we're going to see it would go into suspension. Even so, here, it still would keep your eligibility for Medi-Cal or Medicaid if you're in another state. So, if the ABLE beneficiary is receiving SSI, when the assets in the ABLE account total $100,000, the SSI benefits will be placed in suspension. Okay? And if the assets in the ABLE account drop below $100,000, then the SSI benefits resume. The beneficiary will not have to reapply for SSI benefits once the account drops below the $100,000, as we're going to see, as long as you follow all the other rules. So, a special rule applies when the balance of the an SSI recipient's ABLE account exceeds $100,000 here, and once again, SSA will suspend the SSI benefits so long as he or she remains otherwise eligible. The recipient is SSI eligible for Medi-Cal purposes and Medicaid purposes, and the individual's eligibility does not terminate after 12 continual months of suspensions. For those of you, once again, that are not fluent in this, if you are SSI, in the normal case, if you're getting SSI here and you're not eligible, let's say you have a resource problem or something along that line for more than 12 months, you may have to reapply if you lose your eligibility for more than 12 months. You certainly would want to do that. So what this is saying, as long as you're otherwise eligible, you're to reinstate the recipient's regular SSI eligibility for all the months in which the ABLE account balance no longer causes the recipient to exceed the resource limit and he or she is otherwise eligible. Once again, let's go through an example. Paul is the designated beneficiary of an ABLE account with a balance of $101,000 on the first of the month. Paul's only other accountable resource is a checking account with a balance of $1,500. Paul's accountable resources are $2,500 and therefore exceed the SSI resource limit. However, since Paul's ABLE account balance causes him to exceed the resource limit, here he's over the $2,000 resource limit, suspend Paul's SSI eligibility and stop his cash benefit, but he remains eligible for Medi-Cal or Medicaid in his state. Okay. Note, SSI eligible for Medicaid purposes means that the individual is eligible for Medicaid in states where eligibility is based on SSI eligibility, and in our state we are a 1634 state, so that's fine. No SSI recipient will reach the suspension status for several years here, because at $15,000 a pop it's going to take quite a while. So here's another example. Christine is the designated beneficiary of an ABLE account with a first of the month balance of $101,000. Christine's only other countable resource is a checking account with a balance of $3,000. Christine's countable resources are $4,000 and therefore exceed the SSI resource limit. However, because her ABLE account balance is not the cause of the excess resources here, the special rule does not apply, and Christine is not eligible for SSI because of excess resources. Okay, and once again, if this goes beyond 12 months, she would have to reapply. So they would suspend her SSI benefits here using whatever code it is they use. Ineligibility for other reasons. If an individual is ineligible for any reason other than excess resources in an ABLE account, the special suspension status does not apply. Suspend the individual's SSI eligibility using normal procedures. Example, ineligibility for a reason other than excess resources. And Sam In April, Sam's able account balance is $102,500 as of the first of the month. However, Sam also has excess income here despite the excess funds in the able account. Before the end of April, Sam leaves the U.S. and does not return until July 1st. So he is not eligible for May, June, and July. If Sam still has excess resources in his able account, effective August 1st, and is otherwise SSI eligible, place him in the special able status because he was not ineligible for a full year. He had these periods when he wasn't ineligible, but it wasn't a full year. And he is also eligible for Medicaid. A distribution from an able account is not income, once again, but it's a conversion of a resource from one form to another. So if the and this is something that is a little hard to get one's arm around, and quite frankly, as we're going to cover, this is one reason why I would suggest that if you're paying for a QDE, don't take it out of your able account and put it in your personal checking account. But we'll go through what happens if you do. So count a distribution for a housing expense or for an expense that is not a QDE as a resource if the designated beneficiary retains the distribution into the month following the month of receipt. Okay, if the designated beneficiary spends the distribution within the month of receipt, there's no effect on eligibility. In a way, isn't that huge? Whether you use it for a qualified, a QDE, a non-qualified expense, or for a housing expense, it's not to be counted as income. In the calendar month, it comes out of the able account. However, apply the normal SSI resource counting rules and the exclusions to the items purchased with funds from an able account. Example here is distributions intended for housing expenses. Amy takes a distribution of $500 from her able account in May to pay for a housing expense in June. She deposits the $500 into her checking account in May and withdraws the $500 cash on June 3rd and pays the landlord. This distribution is a housing expense and part of her checking account balance of June 1st, which makes it a countable resource for the month of June. Had Amy done that all in the month of May, then it would not be counted. Count the amount of the funds used for non-qualified expense or housing expense as a resource as of the first month of the month in which the funds were spent if the designated beneficiary uses the distribution for a non-qualified purpose or a housing expense. If the individual's intent is to use the funds for a QDE changes at any time, but he or she has not spent the funds, count the retained funds as a resource as of the first of the following month. So an example of a previously excluded distribution used for a non-QDE. Sam takes a distribution of $25,000 from his able account in May for an assistive technology device and related service, which is clearly a QDE. He pays a $10,000 deposit. While waiting for the service to be completed, Sam takes a trip to a casino in July. Notice money came out in May and he went to the casino in July, where he loses $1,000 of his able distributions gambling. The $1,000 he lost is a countable resource in July. Otherwise, the $14,000 Sam retains as an excluded resource while it meets the requirements of the POMs in this section. Here's an example of a previously excluded distribution used for a housing expense. In June, Jennifer takes $7,000 distribution from her able account to pay the educational expense that is a QDE. Her education expense is due in September. However, she has to make a $750 advance rent payment to her landlord for her college apartment in August. Once again, here she took out the money in June and she's paying the housing expense in August, and that's where we have the problem. She uses some of the distributions she took in June to make the rent payment, which is a housing expense. The $750 is a countable resource in August. Exclude the remaining $6,250 of the retained distribution while it continues to meet the requirements of this section of the POMs. Okay. Example of a change of intent, and how they would track this, I have no idea. In June, Jennifer takes a $7,000 distribution from her ABLE account to pay for an education expense that's a QDE. Her education expense is due in September. In August, Jennifer gets a job and decides not to go to school. The $7,000 becomes a countable resource in September because she no longer intends to use it for an education expense that's a QDE unless she redesignates it for another QDE or returns the funds into the ABLE account prior to September. By the way, most of the ABLE programs, as far as I know, all of the ABLE programs are not going to ask you what the intent is. So that's something that you would have to keep track of yourself. So here's an easy fix after going through all this, and then we'll start getting into the examples. Many ABLE programs have methods, including debit cards tied to ABLE accounts, that allow the person with signature authority to pay directly for the ABLE beneficiary's needs, eliminating the chance of this sort of a problem. Okay, so here we have our second of three codes. So our second code here is 5671, and this is code number 2. So what if the beneficiary is not getting SSI, but is on Medicaid? Okay. And so one of the things that we will be sending you is the CMS memo that was issued before these POMs that basically says that ABLE account beneficiaries may be a beneficiary of a special needs trust or pooled trust here, and distributions from those trusts made on behalf of the trust beneficiary to the ABLE account are not treated, should be treated as contributions and should not be treated as income. While disbursements from the trust could be considered in some cases income here, what it's basically saying is that even if you're not on SSI, if you're only getting Medi-Cal or Medicaid here, that distributions from a special needs trust, whether it's self-settled or third party, into an ABLE account is going to be considered a contribution. It's not going to be considered income. So once again, what it's telling the CMS memos is actually to the Medicaid directors in each of the states. So what it's telling the directors is don't count distributions from ABLE accounts. So let's go through a few scenarios here. Okay, so one of the biggest things that we deal with here are ABLE accounts for SSI recipients. Okay, now you might remember as we went through this, there are 10 items that are considered ISM distributions. This includes food, but it's actually only 9 that we're going to worry about in these examples. So here's the first example, which I call a little help from friends. Belinda has been disabled from birth and she receives $910.72. For those of you that are watching in other states, we're using the California numbers and we have a state supplement. She is a beneficiary of a self-settled special needs trust. She'd like to make a move to a nicer apartment that would cost $1,000 a month, which would be kind of hard to pay with $910.72. She's going to need some assistance in order to make the move. If Belinda's parents or the trustee were to give her the funds directly, just to give her the $1,000, that would wipe out her SSI completely. If her parents or the trust were to pay the landlord directly, we would take the normal $270 reduction in benefits. If instead they were to contribute $1,000 a month here into the ABLE account, or if the trustee of the Golden State Pool Trust did the same, and in turn the funds from the account were to pay the landlord, then there would be no reduction in SSI. Remember, as long as it's done in the same calendar month. Okay. Here's another example, and I know once again the Golden State Pool Trust here, the nonprofit is the North Bay Housing Coalition, so obviously housing is very important to us. So in this example, Sue Casa wants to provide her daughter Mia with a home to live in. Sue is concerned that if she puts the property in Mia's name, it would be subject to a lien. Now, we have a slide coming up to remind us that as long as that house is in a living trust and does not pass by probate, it can avoid the lien. In most cases, my suggestion when I'm doing planning is put the home in a special needs trust anyway. Here, partially because if Mia were someday unable to live in the home and it needed to be sold, We don't want it interfering with her eligibility for SSI, Medi-Cal, IHSS, and alike. Sue is able to purchase the home, and rather than give the title to Mia, she titles the property into a third-party special needs trust. Now, the reason I put in with no mortgage is that in most cases, once again, if you add a mortgage to this, it's going to really jump up the ISM numbers to something where this wouldn't work. So what the law says here under POMS SI 01120.200 is if the trustee of a special needs trust holds title to a house as a home for the beneficiary, the house is not a resource to the beneficiary. It would also not be a resource if the beneficiary moved from the house. The trust holds legal title to the house, and therefore the eligible individual would be considered to be living in his or her own home based on a concept called equitable ownership here under the trust. So the eligible individual here does not receive in-kind support and maintenance in the form of rent-free shelter while living in a home where he or she has an ownership interest. So far, so good. Accordingly, an individual with equitable home ownership under the trust does not receive rent-free shelter. So that's pretty simple. The problem with this is maybe Mia actually likes electricity, water, and that sort of thing. So if the trust pays for other shelter or household operating expenses, these payments would be income in the form of ISM in the month the payment is made. Okay? So Mia can live in the house without having to pay any rent because she has an equitable ownership. She's still going to have difficulty paying the taxes and utilities without some assistance. Sue CASA transfers enough money into Mia's ABLE account, either monthly or annually, to allow her to pay the taxes and utilities with no reduction in benefits. She also establishes, and let's say in this case, a third-party special needs trust managed by the Golden State Pooled Trust, since we're the ones bringing you this information today here. So to continue to be able to make those contributions to Mia's ABLE account in the event that she passes away or loses capacity. Both Sue and Mia feel much more secure and feels that they have the best of both worlds here. Sue has provided a residence to Mia, and if Mia were unable to remain in the residence, the house could be sold and used for her needs without disrupting her eligibility for benefits. If Mia were to be sued, the assets of the special needs trust would be protected. So let's go through a couple other scenarios real quickly, and we'll see if we have time to take a few questions. So Jerry is injured at the age of 25 and has quadriplegia and requires 24-hour care. Much of his care is through Medi-Cal. Okay, he settled his personal injury claim for $2 million, and his counsel is looking for the best way to set up the settlement. Despite Jerry being severely injured, he is fully competent and he's very concerned about losing his independence. And this is actually based on a real case that I worked on. Most of the award will need to be placed in a self-settled special needs trust, but Jerry would like to maintain some control over his funds. I mean, look at this situation in Jerry's case. He's not only lost control of major parts of his body, but he's about to lose control over the award, and that can be kind of difficult. And you know, one of the things that comes up with the special needs trust, of course, is the trustee has absolute discretion and the beneficiary has none. And so, you know, you could understand why maybe Jerry would like to have some funds that he's be able to use without having to ask his trustee permission. So all of the funds can be directed in a special needs trust, and the trustee can transfer funds from the trust to an ABLE account for Jerry. This would allow coordination of the deposit amount with the gift tax exclusion. Now, Jerry could not compel the trustee to make that transfer, okay? With that, could Jerry have some settlement placed in a structured settlement that's irrevocably assigned to an ABLE account here? And I believe that is possible, but that's one of the things we're going to have to be careful about. Remember the child support example. We're not 100% sure how SSI, how the Social Security Administration would treat this, so we may have to wait for further case law to come up. Let's go through another example real quick, and we actually have this case. Kramer has severe cerebral palsy, and his tremors is reduced significantly by using medical marijuana, or as we call it at the Golden State Pooled Trust, medicine. Okay, so Kramer is about to get a large settlement, and the funds need to go into a special needs trust to maintain eligibility for public benefits. Newman, the trustee, is not comfortable paying for the marijuana, and moreover, purchase of the marijuana requires a cash transaction that cannot be readily handled under the trust. An ABLE account funded either by a structured annuity or through the trust transfers would allow Kramer to withdraw cash for his marijuana purchases. Now the question is medical marijuana a qualified disability expense? Every ABLE administrator I have talked to has said that they don't think that it's a problem. Okay, does it matter that the IRS does not recognize purchase of a controlled substance, which is illegal under the federal law, as a qualified medical expense? If you go back to the penalties, though, even if this is a non-qualified expense, as long as he doesn't take the funds out of the ABLE account, put it in his own account, and hold it over into the next calendar month, we should be fine. So once again, this will demonstrate how this can give a little bit more latitude to the beneficiary of a special needs trust. Let's go through two more examples here. Archie is a nephew named, has a nephew named Michael who is on SSI and Medicaid, and he would like to make a gift of $60,000 of appreciated stock with a basis of $5,000 to Michael's ABLE account. Michael's fully competent and can establish an ABLE account as well as manage it. Now there's two problems here. The ABLE account only accepts $15,000 a year, and contributions must be in cash. To make the gifts directly into the ABLE account, Archie would need to sell the stocks and realize the gain and contribute the after-tax funds into the ABLE account. If Archie gives the stocks to Michael to sell, then he would lose eligibility for his SSI and Medicaid the calendar month he receives the stock, and would remain ineligible until the resources drop below $2,000. If Archie creates an irrevocable third-party special needs trust with Gloria as the trustee, then Archie can transfer the stocks into Michael's special needs trust, and then Gloria sells $15,000 a year of stock, or enough of the stock here to give us $15,000 a year in cash, or whatever the amount is as the cost of living increase goes up, and transfers those funds into the ABLE account. Also, keep in mind, if you're doing this, each year the trust will be eligible for a qualified disability trust exemption, which is $4,115 in 2018, which would probably shield all the gain realized from the sale. In fact, one strategy might be to sell the stock based on an amount of the QD, the Qualified Disability Trust exemption, the trust might have, and possibly diversify the investments in other growth funds. Here's our last code, which is MCLE code number 3, which is 8181. Here's our last example here. A child with a disability here has a housing need of approximately $1,250 a month. Okay, his parents, Ozzie and Harriet, are divorcing, and the attorney for Ozzie, the custodial parent, is considering seeking an order for formal child support to her client in this amount. What issues does that raise? And part of this is, for those of you who do special needs trust work, working with the family law bar is a growing area here. And so once again, we do a fair amount of work in that area. Has the divorce attorney even thought to ask her client whether the child is receiving needs-based benefits? If so, will the child support cause a reduction in the child's public benefits? Well, the POBS makes it clear, the revised claims, that you cannot use an ABLE account for child support directly, but it does allow support to be irrevocably assigned to a special needs trust, and then the trust pay the ABLE account and then pay the housing. Now, we're going through this, and we have done this before. Does the family code allow the judge to do this? Does the court have the jurisdiction over the ABLE account? Who's in control of the account? These are some of the issues you may be dealing with the family law court. Now, child support and means-tested programs here for SSI and Medi-Cal actually don't mix in a traditional sense. Child support will reduce or eliminate the SSI, And if the SSI is eliminated, the child can lose the Medicaid eligibility. What it basically says is child support payments made on behalf of a child on SSI are earned income to the child. And if the child who the support is being paid, once they turn 18 or 22, if they're a student, 1/3 of the amount of the SSI payments made to or for the eligible absent parent is excluded as long as they're a child. After that, then it just becomes income. What the POM says is if you take that and irrevocably assign it to a special needs trust, then it's not counted as income. You can go one step further with this, and then at that point transfer the funds from the special needs trust into the ABLE account, have that pay the landlord, and get the result that you're looking for, which is being able to use the support for ISM without a reduction in the SSI, which once again could have a great amount of benefit. Okay, now let's go back to this for the few minutes we're going to have to maybe take a couple of questions here. I would encourage all Californians, if you're a California practitioner here, a beneficiary, an advocate, a private fiduciary, whoever you might be, to go to the CalAble website here and not only bookmark this, but the other thing is if you go through this, you can sign up for alerts having to do with when they do education and that sort of thing. This will also let you know when the CalAble program is up and running. I believe it'll be a fine program, and personally I would rather them take their time and do it right than try to rush through this here and create a program that has problems. So anyway, with that, here we had a few technical problems, but I want to thank you for watching here. For those of you that are looking for MCLE credits, you would email Shelley, SHELLEY, at gspt.org, and she can send you the proper form for you to fill in to do your evaluation here, and also to put in the 3 codes here to show that you actually watched this. I think with that here, let's see if there's a few questions because we had some technical problems here. We may not be able to get to as many questions as we would like. And in fact, here, well, I know that Amy is tracking questions here. Here we go. So one of the questions we did have here was whether it's okay for a beneficiary to deposit their SSI check into an ABLE account. And yes, it is okay to do that, but it's still going to be income, okay? So that's something you can do. Okay, with that, I want to thank you for watching today. Also, if you would subscribe to our YouTube channel for the Golden State Pool Trust, when we get over 100 subscriptions, we'll actually get our own vanity name on it here. So also we will be doing 10 of these programs this year. So in order to get on the mailing list, if you would email Shelley at gspt.org, here you can keep up with any of these programs. With that, I want to thank you for watching today here, and this is Steve Dale signing.